you sit down here, you're gonna have to tell me how to vote.
I'm not gonna tell you how, I'll tell you when.
You know how to do that.
I watch Larry's. Yeah.
One is hold up one finger, that means yes. Two, it means, here.
Yeah, that's the way it is at my house. That's what my wife does.
I got to have that, I got to have somebody with.
Yeah. I'll just let you know when it's your turn.
Well, I'm sorry. I can't hear them.
Yeah. Yeah.
He can move it all down on us now, we don't see. You don't want to, we want to.
He's got it. He's got it.
But I tell you, this thing's a lot easier sitting on that bench for an hour or two. I tell you, they get getting uglier every year. I don't know if we can hear you. Yeah, he just looks ugly.
Mayor, have you heard from Ray Seals?
I have. He's got an event or something he's got to be at. He's not going to be able to be here tonight. So I think we've got all the members here.
Well, it's 6:15, I think. So I guess we should start.
Yes, ma'am.
If everybody's ready. So I call the meeting to order and call the roll. Commissioner Goodrow.
Here.
Commissioner Leggett.
Here.
Commissioner Norton.
Here.
Commissioner Perkins.
Here.
And Bryce. All right. So this is the Criminal Justice and Public Safety Committee meeting. For the record, this is April 13th, 2021, and we are conducting this meeting by Zoom. 5 members of the committee are present, and Commissioner Ray Seals is absent. So I declare that there is a quorum, and we move to the first item of business, which is the sheriff's report. Has everyone had a chance to look at the report? Are there any comments about the report? Any questions for the sheriff's department? All right, hearing none,
Can you hear him?
we accept the sheriff's report and move on to the second item on the agenda, which is discussion of Marcy's Law. Somehow there was a copy of this resolution from another county in our packet. Did everyone get a new copy of the Fayette County resolution today from the mayor?
Yes, it's the same one that was in the commission packet, I believe.
Yeah, it was. It was the same language and everything, just except it has Fayette County in it.
I guess the first thing would be to ask if there's anyone who is not on the committee who wants to speak in favor of this resolution. You have 5 minutes to say what you would like to say.
Excuse me, Ms. Chairman, should we have the resolution read?
Hunter Winfrey.
So people understand what the resolution is?
I'm sorry, something interrupted there and I didn't hear what you said.
I think it would be appropriate that the resolution be read so even those that are attending on YouTube can understand what we're speaking of.
All right. Would you like to read it? Or
I think Kevin Powers or Ms. Donovan can read it, given that they are presenting it to this committee.
okay. Commissioner Powers, would you like to read this resolution? Since you are the proponent of it.
Yes, ma'am. Thank you. Because I know Miss Mary Ann is also on the road and is joining us, so it'd probably be easier if I did. This is a resolution in support of Marcy's Law. Reading, whereas the Fayette County Commission, the commission believes Marcy's Law will strengthen and protect the rights of victims of crimes in Tennessee. And whereas the commission is in support of an amendment to the Tennessee Constitution securing permanent enforceable rights of victims. And whereas the amendment of the Tennessee Constitution would preserve and protect the rights of victims of crime, a victim shall have the following rights which shall be protected. Number one, the right to be treated with fairness for the victim's safety, dignity, and privacy. Two, the right upon request to reasonable and timely notice of and to be present at all criminal public proceedings and all juvenile delinquency proceedings involving the accused. Three, the right to be heard in a proceeding involving release, plea, sentencing, disposition, and parole, as well as any public proceeding during which a right of the victim is implicated. Four, the right to be free from harassment, intimidation, and abuse throughout the criminal justice system, including reasonable protection from the accused or any person acting on behalf of the accused. Five, the right upon request to reasonable notice of any release, transfer, or escape of an accused or convicted person. Six, the right to full and timely restitution from the offender. Seven, the right to a speedy trial or disposition and a prompt and final conclusion of the case after the conviction of sentence. Eight, the right upon request to confer with the prosecution. And nine, the right to be fully informed of all rights afforded to crime victims. Whereas a victim may assert the rights enumerated above, the General Assembly has the authority to enact substantive and procedural laws to further define, implement, preserve, and protect the rights guaranteed to victims by this section. Whereas other than is provided in the preceding paragraph, this constitutional amendment will not create any cause of action or claim for damages against the state, any political subdivision of the state, any officer, employee, or agent of the state or of any of its political subdivisions, or any officer or employee of the court. Whereas, as used in this section of the law, a victim includes any person who is directly and approximately harmed by the commission of first-degree murder, a felony, or a Class A or Class B misdemeanor, or who is directly and proximately harmed by the commission of any act that would constitute first-degree murder, a felony, or a Class A or Class B misdemeanor if committed by an adult. The term victim includes a victim's lawful or court-appointed representative, the next of kin of deceased, incompetent or incapacitated victim, or the parent or guardian of a minor. The term victim does not include the accused or a person whom the court finds would not act in the best interests of a deceased, incompetent, incapacitated, or minor victim. Now, therefore, be it resolved that on this 23rd day of March of 2021, the Board of Fayette County Commissioners support Marcy's Law and request that it be considered by the state of Tennessee legislature. I do ask, I'm noticing that it was last month's commission meeting, that we would need to change that to the April date.
Thank you.
Thank you, Chairman.
All right, I'll return to the question of whether there is anyone who wants to speak in favor of this resolution who is not on the committee. All right.
This is Mary.
Mary Ann Donovan,
Yes, ma'am.
a lobbyist for the group that is promoting this resolution.
Yes, and I'm not a lobbyist. I do want to say that, you all, because I'm not a lobbyist registered in any way. I'm an actual employee of the cause that's privately funded. And so I just want to make sure that you all know we do have a 1998 Bill of Rights, but within that Bill of Rights, there is no enforcement. And so I think at number 9, when you all read the rights enumerated in this section, the victim has the right to assert those enumerated in this section, that's kind of the enforcement piece that's huge for us because, you know, we like to hope that everyone does the right thing all the time. And that's not always the case. I'm sad to say I have so many just examples across our state of where victims were not treated with those rights that are already embedded in our Constitution, and nothing happened as a result because the enforcement piece was not there. And so that is a law without enforcement is merely a suggestion. So we need to make sure that we're changing that. And I recognize that a resolution, you all, is not that you all don't have a vote when it really comes down to Marcy's Law. But let me tell you, you're closest to the people with government. And so showing your support on a local level that you all believe victims deserve these rights sends a message to your state lawmakers who do have a voice. So I'm going around. My hope is to every county to get the counties to pass this. I have already gotten Shelby County to pass it. Fentress County has passed it. Tipton County, we plan to hear that in Tipton County as well. So that's my mission, because I want those legislators and senators to know that the people closest to the elected people closest to the people know that this is a popular thing. In 1998, it passed with 88.8% of the vote once it went to the ballot. I honestly believe that when this goes to the ballot with today's climates the way that they are, and people kind of as my husband always says, if a judge wants to blow off a victim or blow a victim off in the district attorney's office, there's no recourse for that. And so, as most of you know, I am a victim. Well, the state did not consider me a victim. My fiance was killed, and I was told, I lived with him, I was engaged to him, but I was not considered a victim because I was not married to him or related to him. And so Marcy's Law will also include someone who's directly impacted. And why is that important? For those notification reasons. I was told by the DA's office that I was not legally entitled to any of those rights. And so that's why it's near and dear to my heart. So I won't use the whole 3 minutes, but if you have questions, I'd love to be here to answer those.
Is there anyone else who would like to speak in favor of this resolution? Is there anyone not on the commission who wants to speak against the resolution? Okay. Hearing nobody, I move on to the next order of business, which would be, I think, to let everyone speak if you want to. And I do it in the same alphabetical order that I call the roll in. Commissioner Goodrow, do you wish to speak about this at all? To have any comments on it?
Yes, Ms. Donovan. In a nutshell, the difference between what the laws we have on the books today and the Marcy's Law, as I understand it, is Marcy's Law would be enforceable and it would be a constitutional amendment, which obviously has a stronger backbone. Is that correct, or is there other differences?
There are a few others, but yes, so the biggest thing for us is the enforcement piece. And some people say, well, why can't we do that in statute? Well, if we do it in statute, then the offender's rights, enforceable constitutional rights, will win every time over a victim's enforceable statute. And so it has to be done in the Constitution. And so I do want to make sure you know that, like, the top things that Marcy's Law is going to do is it's going to add the enforcement piece, which is key. It's going to allow the judicial discretion to consider someone else as a victim. And again, what does that mean to be named a victim? It means you have access to the information, court dates, release dates, that type of information. That's really important so that you can make sure when your loved one is killed that you can be present. And then we are extending these rights, because right now these rights are not included in general sessions and juvenile courts. And there are those A and B misdemeanors. There are some pretty severe crimes that have stalking attached to it, some rape cases attached to it, especially when they get pled down. Or in juvenile court, if your family is is harassed or threatened or anything happens by a juvenile, you're not entitled to these rights embedded in our Constitution right now. And so, yes, so we are, it does a little bit more than just enforcement, but the biggest piece of it is to know that it has to be done in the Constitution for it to be equal to the offender.
Thank you, Ms. Donovan.
Thank you.
Mr. Leggett, do you have
Thank
any
you.
comments?
Yes, I worked homicide for about 9 years. And of course, in doing so, you become very close generally to the victim's family. And, you know, there's just nothing out there that can speak to them and let them know that the law is on their side, because so often all we hear are the inmates' rights, which those are enumerated in the Constitution. But at the same time, I think that we as a government, and especially as a state government, we need to be sensitive to the fact that, especially in homicides and where there's a death involved, that's an injury that never goes away. These families have to just learn to live with it. And when they don't think that the DA or the law is generally the way they refer to it, that the law is protecting them, I don't think that we can do enough to try to bring the victims on board to where they can feel like they had a part in seeking justice on the behalf of their loved one or family member that got killed. So I certainly am in support of it. And I think that it should be a constitutional item as opposed to a statute, because statutes can be repealed. It's very difficult to go in and change the Constitution. So I'm in full support of it.
Thank you, Commissioner.
Mr. Norton.
You're muted, Jim.
I'm sorry. Thank you for that. Thank you, Madam Chairman. Being in law enforcement, as Commissioner Leggett had alluded to, I think this committee has 4 career law enforcement officers on it. And the number of years that we've been in there, it kind of gives us a little insight into Ms. Donovan's plight. Now, I can't speak on the behalf of a district attorney, nor can I speak on behalf of their assistants, because I've never lived that life. I have lived the results of it, but not the decision-making process it goes through. So, Ms. Donovan, does Marcy's law, does that give the victim the right to be heard by the jury?
Thank you. That's a great question. So it does not take away judicial discretion. So what happens is, as of now, victims do not have the right to request to be heard. Other than through the district attorney, who has that total control. And sometimes they're not communicating well with us. So it does give the victim the right to request. They can, if the district attorney is not listening to them, is not hearing their voice, they do have an avenue then to go to the judge and make that request. Now, the judge, it is a voice and not a veto, which means the judge has final discretion on how that victim may or may not be heard. So yes, but it does give us at least the voice and opportunity to ask.
Okay, so presently with today's law, the way that it's written, you may want to speak to the judge, but the DA can ban you from doing that. Is that what I hear?
That's been my understanding, and that's been my personal experience as well. Yes, we don't typically have access to the judge, and so this would give us an opportunity to request to be heard. And again, this is the beginning steps, and so our best case scenario for Marcy's Law to pass, because the Constitution is so difficult to amend, as well it should be, is going to be 2026. So we have many years to get ready for this, and then the implementation would be done by the Tennessee General Assembly, not by Marcy's Law. So our state lawmakers will have the kind of the control over what that implementation looks like, because we don't want to hurt our local law enforcement. We don't want to hurt our DA's office. We want to help victims, but we also want to be a tool, a constitutional right that law enforcement and district attorneys can use in order to fight an offender's constitutional rights.
I understand. And out of curiosity, have you discussed this with other district attorneys in the area? And if so, what's your feed on that? What was the feedback you got?
So, of course, you know, I have everything that I say publicly, I have said to them privately. So I'm an open book. And yes, I have had, you know, and they say, well, we're concerned about resources. And I say, we're always concerned about resources. Everyone is, and that's not going away. I just don't think that it's fair to say that victims should be the only people who have to wait for what's right, because we don't make offenders wait for what's right based on resources. And so why would we say that to victims when they're the very people who didn't ask to be put in the situation in the first place? And so then I would add that if Marcy's Law passes, let's think about that now. Well, first of all, now you have a tool in your toolbox where you kind of have to have resources because it's a constitutional right. So you're more likely to get resources with Marcy's Law than without it. And then second, I would venture to say that come 2026 or 2027, when it's implemented, we would have electronic notification by then, because many states are already using it. Tennessee should be. So 6 years from now, it'll probably be electronic, which means district attorneys are not going to have to worry about the things they're stressing about today when Marcy's Law is 6 years away from passing. I can't imagine 6 years from now a DA having to pick up a phone and leave a voicemail. Or I just truly, with all of my heart, would, before I give any excuse as to why we need it, the number one reason is because victims deserve it. And so we deserve to continue the conversation, because if we pass this year, we still have to skip a year and come back the following year and get 2/3 majority. And so why would we kill something so important right out of the gate before we've even begin to have the conversation? And I have let it be known to all district attorneys, including my own, might I add, that I'm very disappointed that we're not standing up and being a leader rather than being a follower, because the district attorneys conference isn't who elects them, the people do. And the people have already voted once on this with almost 90%. And if we let them have a chance, I'm sure they'll vote again. And so I'm disappointed in our district attorneys, to say the least.
Well, very good. All right. I'll just leave it with this then. We are so blessed on this committee to have the law enforcement that we have, and to have a leader of this group with our chairman or chairperson, who was, and like I said, once you're a cop, you're always a cop. Ms. Rice has been a district attorney, and I know she's going to have the mindset of that, and it's going to be very interesting to hear what she has to say when she comes around. And I'll reserve judgment until I've heard everybody at this point. Okay.
Thank you so much.
Yes, ma'am. Thank you, Madam Chair.
Thank you, Commissioner Norton. Let's see who else we have. Commissioner Perkins.
I would just have one
I
question.
can't see Commissioner Perkins. Sorry. Tommy, did you want to make any comments?
Yeah, can you hear me? Okay.
Fairly well.
Keep talking. Okay. Oh, okay.
David, if you back up a little bit.
Okay. There we go. I just have one question.
That's better.
How how does this work out if we continue to try it through the laws of Tennessee without going through the change of the Constitution? And that's
Well, so yeah, we, of course, the district attorneys have said to me, they have a whole slew of bills that are victim friendly that they want to change within this statute. And my response to that is I'm for it. So anything that they're doing to help victims in statute, I'm for it. With the thing and the reason we still need Marcy's Law through the constitutional amendment is because if we go to court, and I'm going to give you an example with rights that are statutory as opposed to an offender who has constitutional rights, their rights far exceed ours and they win every time. And here's an example. And I watched the case. I actually had a DA call me and said, Marianne, I want you to watch this. This is exactly why we need this. And there was an officer that was shot and killed on video. And it's been 3 years since they've gone to court. And so he literally goes to court with the victim's right, constitutional right, that says the victim has the right to a speedy trial. This happened 3 years ago. It's on video. The man who shot him keeps delaying and getting new attorneys. Well, when he gets new attorneys, it's their delay tactics. And so the other side argued, well, we're getting, I'm a new attorney and I need time to get my case together. Well, it's been 3 years. And so the DA did a great job arguing right to a speedy trial for the victim. But when the judge ultimately kind of came back, he mentioned that, if I don't do it right on the other end, then we may have to come back and start over and redo all this. So he was basically saying they have a right with enforcement. So if I don't uphold their right with enforcement, then we'll have to do this over again. Well, we want to have that same right. So then now he's weighing apples and apples, because right now he's not. It has to be done in the Constitution. Do I support every victim's bill the DA has? 100%. But if it's not constitutional, then it's not apples and apples.
Well, thank you for that. I'm the only one that's not law enforcement, but I'm just an old soldier. So,
well, that matters. Thank you.
Well, they never die. So good for you. Thank you, Tom. All right. I guess, does anyone else have anything they want to say or questions to ask at this point? Okay. Well, I was shocked when I saw this resolution in our packet last month, I guess. And my first reaction was that this is something that is not needed. We already have a constitutional amendment, which was passed in 1998, and it is very similar to this proposal, with the exceptions that you all have discussed about the enforcement part and adding general sessions and juvenile court, I guess would be the two big ones. Now, since the 1998 constitutional amendment, there have been numerous statutes that have been passed, and I hope you all got my message last night, this morning, with a link to look at some of those statutes. There are many statutes that have been passed in support, procedural things and new things, anything that would, things that are consistent with that constitutional amendment. But if we are going to change our constitution over everything that everybody wants, the Constitution finally just becomes meaningless with these amendments. And you cannot, I just take it more serious. I take the constitutional amendment as being much more serious than other people seem to think it is. But this really is not a local problem. We are a local government group. It's not a local problem. As far as I know, no complaints. I've had no complaints from constituents about victims' rights. Our DA's office has taken this seriously and I think have done everything that they're supposed to do. Part of it, someone said, really this is a matter of common courtesy to keep victims informed and to keep in touch with them and to let them know what's going on and to explain cases and so forth. But, and actually you're going to need the victim anyway, and they're going to be notified because you have to have them to establish that a crime has been committed, what losses have been sustained, when the crime occurred, the identity of a deceased victim, the venue of the crime. There's so many things that you're going to have the victim there and they're going to be testifying. Now, I prosecuted cases as a DA or an assistant DA for 29 years, and then 5 more as a DA pro tem under contract with the DA's conference. I have also represented my husband's family in Shelby County when a first cousin was killed by a drugged driver about 3 years ago. And I was the person who was closest around here and able to make all the many dates that were set in criminal court in Shelby County. They did an excellent job of keeping me notified, and not only I was the designated person to go to the morgue and visit and identify the victim and get to all the things down at 201 Poplar, but they also, in addition to me, even though I was a designated person, they kept everyone else informed in Atlanta and out on the West Coast about what was going on by email or other means. But I think that the DAs, as far as I can tell, are doing an excellent job of trying to keep everyone informed. And the big concerns, I think, some of the concerns for the DAs and for me are the cost of what it will cost to gear up to do all this notification. The DA's conference has estimated that it will cost $16 million. Now, locally, we're going to have more costs if you add in general sessions and juvenile court, because those will probably require DA resources as well as clerks, judges, and so forth. The general sessions court has the bulk of the cases. And that's huge, and it changes quickly. I remember one day in Tipton County, arriving over there in the morning, and there was a big stack of warrants on the desk, and there were 80 cases there. We handled 80 cases that day. Now you've got to have, I cannot, standing there, notify victims of everything that's happening on 80 cases in one day. You have to have some more support staff to help with that. So it's going to be very costly to do this both locally and statewide. Now, as to enforcement, I heard Ms. Donovan speak the other night, and she was talking about do-overs as being the way to enforce this. That if a victim, if someone is not notified and they feel they should be notified, that you would have to do a hearing over, or whatever it was, over again. And in these more serious criminal cases, there are many hearings. And if somebody failed to be notified and had to do over all of this, I cannot imagine what that would do to the dockets in the courts. Another problem that apparently has occurred in other states is the trying to get victims notified prior to setting a bail As all of you who've been in law enforcement know, you have to arraign and set bail very quickly. Most likely before, well, certainly before the DA's office is aware of a case. And apparently the problem is that you have to hold these defendants under Marcy's law. You got to hold them until you can do all your notifications. So you end up with people in jail longer than they should be. Now as I see it, we are a local government group. We set the tax rate, do the budgets, deal with roads and bridges, jails, ambulances, fire departments, law enforcement. And we have, I think, about all we can handle with road repairs, a library, which is allegedly falling apart, the courthouse, which is definitely falling apart, animal shelters, solar farms, and trash everywhere. And we do not need to be joining a California crusade, which has been organized and bankrolled by a billionaire whom we don't know, and whose publicity certainly raises some serious questions. Now, anything that is that's needed in Tennessee can be accomplished through statutes under the 1999 Constitutional Amendment. And there simply is, my way of thinking, there's no need for this. Now, you cannot really equalize, that's another thing that I keep hearing, equalizing the rights of victims and the rights of a defendant. It's comparing apples and oranges. The defendant has certain rights because his life is at stake. The victim's life is not at stake. Or the defendant's liberty. His life and liberty are at stake. And it is very important to get any conviction, to get it and have it be right. Definitely not be, you do not want to convict someone wrongly. I can't imagine how that would feel to have that on your conscience, that you had convicted someone and had them serve years in jail, and it turns out they're not guilty. So that is the reason for the rights for them. And I don't think you can possibly weigh that against a victim's right to be informed and to testify and to know what's going on in their case. It's simply two totally different things, and we should not be trying to equalize those rights.
Madam Chairman?
Yes, Commissioner.
I would like to, I take exception to a lot that you passed on there. The DA is the attorney for the victim.
Yes.
Well, they need to spend as much time with their client as the public defender does with the defendant. And the public defender's office does not complain about resources. I have spent my whole life working with victims, and obviously there's some difference between a police officer's relationship to a victim and a DA's relationship to a victim. And I mean, you know, I'm somewhat appalled about it, that you say that there's no difference. The victim has to live with the crime that the defendant did for the rest of their life. Just like the defendant, if they have to go to jail for the rest of their life, if they're guilty, I feel no sympathy. But having said all of that, I'd like to make a motion that this committee recommends this to go to the full commission with a recommendation for passage.
Right. Can we wait and be sure everybody is heard? I'd like to respond to what Commissioner Leggett is saying, that the DA represents the victim. The DA represents the people of the state of Tennessee. And that includes the victim, but the DA is not the victim's lawyer, like an attorney that you hire to represent you. It's totally different.
Madam Chairwoman.
There's a motion on the table.
Okay.
Ms. Donovan,
May I respond, Commissioner,
Yeah.
to your something that you said?
you had something.
I really have to respond because you say that the defendant's life is on the line. Let me remind you that in my case, Chris was killed. No one's life is on the line more than the victim who was murdered. He was absolutely killed, and his right should not die because he was murdered. And so what you just suggested is the defendant's entitled and should have all those rights, and that Chris should have none. And so you have to understand that you laid out everything that you got. Well, you were a former district attorney. You were probably treated different than most people. I have example after example of people who weren't treated with the respect that you were given, and I'm one of them. And so the only thing that I'm over here that I'm saying is you talked about funding libraries and courthouses. Why would victims not deserve an equal enforceable right within the Constitution over a library? These people their lives are traumatized. And what you've read are the DA's talking points, because I've seen them and I've heard them. They gave those to you. There is nothing that exists that proves those numbers are right. And I have to point out that there's an opt-in clause, which means those 80 cases that you're talking about, well, law enforcement on the front, there's no cost to local and law enforcement. Law enforcement already in the Bill of Rights says they're supposed to be notifying victims of their rights. There's nothing that's going to change on that. Think about it. If we don't do something right to the defendant, there's a do-over. And you know why we don't have do-overs? Because we try to get it right the first time. So if there's a consequence for a victim, that means the DAs will try to get it right the first time. And by the way, everyone won't opt in. Some people won't care about their rights. Some people will say, no, I'll opt out. And so those 80 cases become very few. And again, when a DA is doing the right thing, like you said, then those people aren't going to need, you can take them off the table as well, because we're treating them the way they deserve to be treated. But there still may be someone along the way that's not treated fairly. And right now we protect defendants more than we protect victims. And so let's please not say that I'd rather fund our courthouse or fund this over worrying about a victim, because that quite frankly, that hurt. And Chris is dead. His life mattered too. His life is on the line. And so your defendant that you, as a former DA, you fought harder for the murderer right then than you did for a victim. And that's what I'm dealing with other DAs right now. So I'll end with that.
Ms. Donovan, I'm not saying we should spend money on a library rather than on a case. What I'm saying is that this group is a local group, and we have all these things that we are needing to do. This other is a statewide problem. We've had no problem here about victims, as far as I know.
I can bring them to testify if I need to.
Madam Chair.
That's not something that is.
There's a motion on the table, please.
Madam Chair, please.
Commissioner.
Yes, ma'am. I would ask unanimous consent of the committee to suspend our rules for the purpose of debate.
We've only got 3 minutes left on this thing. Does anybody else want to say something else? I think we're pretty well. I'm sorry. Couldn't hear you, Commissioner.
Yeah, that was the purpose of my asking to suspend the rules.
Yeah.
I understand we have 3 minutes. I would like to suspend those rules for the purpose of debate. I think this is a very, very urgent, important topic that we're discussing right now. And I don't think we need a clock looking at us to make a decision on this. You've raised some very valid points. The other commissioners have raised some very valid points. And I would hate for us to rush because we have a clock in front of us to a judgment.
All right.
I think Ms. Donovan deserves more than that. And I think that we should allow some time for debate on the subject.
They'll have to have a roll call vote, I think, on that. And I understand, Commissioner Leggett, that you have made this motion, but it came before we could finish what people needed to say. We had people waiting to speak. All right, so.
Excuse me, Madam Chair. Do they typically do this during the development committee? Because my committee after development committee has started late because they ran over. I don't know if we had to vote. I don't know if they had to vote to continue on beyond 45 minutes. I think we should just go ahead and have the discussion and go on with it.
Madam Chairman, having been being a member of the development committee and we did run over, we did not take a vote in order to go over. Our meeting just continued.
I don't think we're constrained by what the development committee did. Mayor Taylor, could you be the parliamentarian on here?
I think at this stage, this is just a recommendation. You're having discussion. This is not binding. Anything comes out here will be a recommendation to the full commission. I think you have some latitude of going over. In fact, I'm just before letting some folks know. So I don't think you need to go on another half hour or so, but if y'all want to have a short discussion, I think you're in good shape.
Maybe another 15 minutes.
Point of order.
Yes.
Point of order, Madam Chairman. I believe that you should have a motion and a second before you have discussion.
That's fine.
I second your motion.
All right.
Have a vote.
Yeah. All right.
Are we up for discussion on
Commissioner
that?
Norton, you're recognized for whatever debate you'd like to.
Yes, ma'am. Thank you very much, Madam Chair. I hate to be a pain.
That's okay.
But there was some things that I took notes on. I understand that you're concerned that one of the issues was that this is not a local problem. And as much as I agree with you on that, it's only not a local problem because of the quality of district attorney that we have in our midst. We have elections that do come around, and we could possibly have a different district attorney that we might not we might not be able to say that it's not a local problem. It may very well be a local problem at that point. So I kind of, let's just say I put a con by that one. And yes, they've done a very good job at keeping victims notified. But I go back to what I just said. We can't be assured of that. Under Marcy's law, if I understand, and Ms. Donovan can jump in there if I'm wrong, but as I understand, this kind of handcuffs you and says, no, you will notify the victim. Not that you can, and not that we've been doing a good job. And with that, I do know that you're going to probably have to hold an inmate or a suspect, not really an inmate. You might have to hold him a little longer to set bond. And he has an absolute constitutional right to bond. No, nobody's going to argue that. And there's going to be cost associated with it. I agree 100%. There's going to be cost. We can't put a price tag on a victim's rights. We can't do that. Nor can we put a price tag on the defendant's rights. Nobody here is a greater advocate of constitutional rights and privileges as me, including to the defendants. The defendants have those rights. I think that Ms. Donovan is expressing to us she only wants the same right. And if in fact the law that is on the books now does cover all this, then that's great. However, I don't know if it's constitutional or if it's statutory. If this will enhance that law, then I'm all for it. But if it's going to impede that law, then I might want to rethink that. But I'm not hearing much that's telling me that they're going to impede the law with what Marcy's law is trying to say. So I don't like to think that we're going to make a decision based on well, it's going to cost more money. We're in the business of spending money. We're in the business of providing safety and services to our constituents. And if our constituents is a victim of a crime, what we have to do, we have to do. We can't put a price tag on that. I think Ms. Donovan has made a very valid case. And as much as I appreciate, and believe me, I do, I think very highly of you as a district attorney. I've heard nothing, I've never been before you as a district attorney, but I have been with some of your investigators, and I've been with some of the other attorneys that have been there, and they have spoke very highly of you. So I am assuming that you are already providing the services that Ms. Donovan is requesting. My problem is not everybody is Commissioner Rice. Not everybody is General Donovan, is not General Mark. I can't even call his name now. Yes. Not everybody is that way. We have a wonderful staff of DAs, ADAs. Wonderful. I've worked with many of them, and I've been completely satisfied with how they treated the victims and everything. And with that, I'll yield the floor to anybody else that would like to have discussion on it.
I'm still writing letters to the parole board because victims are still contacting me. I had 2 on murder cases last year. It never ends.
Right.
Commissioner Goodrow, you're sitting forward. Are you wanting to speak again?
Yeah, I'd like to yield whatever time I would have taken to Ms. Donovan to see if she has anything else to say in rebuttal or just general support or questions that have been raised. I know there's one question. I want to know where this $16 million cost estimate came from. And if Ms. Donovan can explain that, I would appreciate it.
Thank you, Commissioner. Our bill at this point there is no fiscal note. These numbers are fabricated, and I am confused as well. I keep hearing so many numbers being thrown out when no one knows. We can't even compare Marcy's law in other states to our language because every state gets to create their own language. Our state rep and our senator in Tennessee has control over what our language looks like. And so what I can tell you is we don't know that number, and we can't base it on other states' language because ours is very, very different. And then I can also say to you, again, we have 6 years to figure what that implementation is going to look like, which means we can start now. This is what I've said to the district attorneys. Why don't we start now? Why don't we try to do our best now and take really good notes and allow this to live in a little bit longer so that or move through the process, because it's a lengthy one, 6 years. And while we're taking those notes, 6 years from now, we can have real numbers. Here's where we noticed our gaps are. Mike always says, you know, if you know there's a consequence, you're going to do it right the first time. And so as far as redoing it, do it right the first time. As General Rice says, we're already doing that. Okay, if we're already doing it, then we don't have to worry about it. But secondly, you all, there are some courts where it's not covered. How many times do I hear victims say, I called to find out where my case was, and they said, oh, they pled it down in court and that it was over. And so I would say to you that, can you imagine being a victim of a crime and calling and finding out that your case had been pled down and no one called you? I have stories for days about that. And so it really, there's so much happening in general sessions courts that victims don't have the right now to be a part of. And as I've said to General Davidson, you're making decisions for somebody that's been affected, and that's not fair. We should get to make our own decision. We wouldn't dare not give this to the offender. Why am I fighting the only people who are representing victims on some level in court on a victims' rights bill? It makes no sense to me, other than we're worried about a little bit more work, or we're worried about resources. These costs that they keep throwing out, they have no documentation to support that. And so I love our law enforcement. I've always supported district attorneys. I don't want to create an environment that's difficult. My husband wouldn't have allowed me to have this job if even he felt that that were the case. And he's looked over it, I promise you. He said, right is right. We do what's right even when it's hard. And that's all I'm asking you all to do, is to do what's right, even if it may be hard later. But let me tell you, 6 years from now, it will probably be easier than they've ever imagined. In other states, and the California thing, I take a little offense, because Marcy was murdered, General Rice. Marcy, this is named after Marcy, a girl who was murdered. And when her mother and brother were walking out of a grocery store, they came face to face with the killer, and they had not been notified that he had been released. And so while you almost victim shamed a little bit there, because did her brother handle that death right? No, but he was young. His sister was brutally murdered, and then his parents were traumatized as a result. So he grew up without parents there because they were so lost. And so did he handle it wrong? Possibly. But should we shame him on how he handled it? No, because you don't understand in his case, or no one. If you don't understand, great. But how he chose to handle it, we shouldn't shame him for that. He was hurt. And so you all do what's right, even if it's hard, and know that 6 years from now, I can't imagine we won't have electronic means to do this. And district attorneys aren't going to have all of these new resources that they think. And so thank you for giving me the opportunity, because I just can't even believe. And when I go and talk to people over and over, Lions clubs, Rotary clubs, everyone always says, you have to ask for this. Yeah, we have to ask for this. So do what's right, even when it's hard.
Ms. Donovan, I want to thank you.
Oh, excuse me.
You know, like he said, we've got 4 people on this committee who are in law enforcement. I've been in it for 28 years, and I'm still in it.
Thank you.
I've worked in the Sex Crimes Bureau and was astonished when a rape charge was pled down, and it was as surprising to me as it was to the victim. And
thank you.
They've also pled down where they're to a non-sex offense, which would put them on sex offender registry. And so that certainly not only hurts the victim, but hurts the community. And so those notifications so that the victim has an input. So I sympathize with your experiences. I understand some of what you have been a victim like you have, but I understand what you're saying. You have my total support. I will be voting in favor of this. And if there's anything that I can do to help outside of this commission, I believe you'll know how to get in touch with me. Thank you.
Thank you.
Ms. Donovan, you mentioned
Yes.
That the language is different, that it is adjusted in the various states. And I understand that already this bill has been changed in Nashville, and it's not exactly the way it is in this resolution. The language has already been changed. Is that correct?
Well, I can tell you that it started out very different. And so just so you'll know, our language has changed because of all of the compromises we've made. We also have the support from Lieutenant Governor McNally, from Speaker Cameron Sexton. This language has gone through the governor's office. We've gone through the state attorney general's office. So everyone has had some input. So yes, we have made concessions, even with the DAs having several things. So we are not taking our own thing and just cramming it down their throat. Now, and right now,
can you tell me what's different now from what's in this resolution that we're looking at tonight?
so as of right now, nothing. That is still our current bill. I can tell you that there is as with right now, the General Assembly is going forward. And so I can tell you that right now, there are discussions of an amendment. I'm not sure that that will that will be presented. It hasn't been given to us yet because it hasn't been approved yet to be presented to the committee in that way. So as of right now, what you have is good. Now, here's what I can also tell you. If an amendment is accepted, it won't be anything that's harder than what you're seeing. It would actually be more favorable in your direction, I would imagine, because we do have the district attorneys asking us to weaken our bill. And I have one legislator who said he's mad because we're doing it. And so because victims deserve better, but are the talks still going on? Yes, but I can tell you they also sent what I know, some of what they sent was, to remove certain courts altogether. And then we go back to, there would be so many victims who wouldn't have access to those rights. And again, why doesn't all victims have access to rights? All offenders do. And that's, so as of right now, what you're voting on, again, it's just to support victims. You're just supporting victims. That's what I'm asking for you all to do, is to support victims.
But the resolution,
that's right,
has all the wording of this Marcy's law, and that is not actually probably what's going to be there for the legislature to vote on. It's
well, as of right,
it's in the process of being changed.
As of right now, it has not changed. And again, if there are more concessions made, then there would be some things that you would be happier with, as opposed to some of the others who, as myself, are happy with this language and the language that we actually started with. So it would not get, it would not be more victim friendly. It would only pull out some things to where less victims would be notified. But the gist of it itself, those rights are not going to change. Those rights and the enforcement is not going to change. It would only change if they agree to somewhat reconsider not including certain courts. And I hope that that's not the case, because I do believe that all victims deserve rights.
All right. Does anybody else have anything real quick before we vote? Then I'm going to call the roll again and ask that you vote yes or no. Commissioner Goodrow?
Yes.
Commissioner Leggett?
Yes.
Commissioner Norton?
Yes.
Commissioner Perkins?
Yes.
All right. The motion has carried, and four commissioners in, four committee members in favor.
Chairman Rice, will you be voting on this?
I think there's no need.
I would. Are you going to be on record as a vote, Chairman? Or are you going to?
I am voting in cases of ties, which we don't have. We have the majority.
Okay.
Four people, four commissioners in favor. All right.
Okay.
This chair will
I think
anyone else?
yes, you're doing abstention.
Excuse me. Does anyone have any other?
That has not always been the case. So I guess you're voting an abstention.
Does anyone have any other business to take up? Is there a motion to adjourn?
Thank you, commissioners.
Thank you for coming.